Okay.
I'm just a panelist. Yeah.
So am I.
All right.
Oh, okay. Mr. Gehi's not going to join us?
No.
So
No,
I guess we can all take turns.
we've changed the name to green card with Greg.
Has
You
a ring
don't-
to it. Has a ring to it.
Yes, instead of green card with Gehi, a common.
We are live now. We can start.
Okay.
Hi, everyone. Welcome to Green Card with Gehi. Today, we're going to be talking about VAWA applications. They're also known as battered spouse applications, also known as abusive spouse applications. They're self-petitions. They have many different names, but essentially, it's when you're petitioning for yourself. So on the panel today, we have myself, Sarai Rahman. I'm the lead attorney at Gehi and Associates. I have with me today, Shima Chowdhury. Shima, you want to introduce yourself?
Yeah, sure. I'm an attorney at Gehi and Associates as well. Thank you.
Okay. And we also have attorney Greg Ippolito. So Greg, you want to introduce yourself?
Of course. Thank you, Soraya. You may know me from last week's episode. I'm Greg Ippolito. I am located at the Ozone Park office of Gehi and Associates. Please stop by if you'd like a free consultation.
Great. And Shima, which office are you at?
I'm at the Jackson Heights office, and we're right by the big subway stop, 1 block from the subway stop, Roosevelt Avenue. So please stop by, and we also have free consultation.
Yes, absolutely. We have 3 offices. We have Greg at the Ozone Park office, as you just mentioned. We have Shima at the Jackson Heights office. We also have an office in Jamaica, and that's located at 17329 Jamaica Avenue, and that's in Jamaica. So we are available in all different parts of Queens to be exact. So let's get to it. Let's talk about VAWA. So VAWAs are a VAWA petition is a petition that can be filed by the spouse of a U.S. citizen or a green card holder, and also the parent of a green card holder or U.S. citizen, but commonly they're filed by spouses. And when would somebody file a VAWA application? Well, let me start with what VAWA stands for. VAWA stands for Violence Against Women Act. And we'll go into this later, but it's not only for women, of course. So it's, for example, the typical situation is where a person who does not have status in the United States is married to a U.S. citizen or a green card holder, but that green card holder or U.S. citizen is not petitioning for the person who does not have status. Normally, that's something a spouse would do. You would want your spouse to have status in the United States. It would make life easier for the spouse and for both spouses, really. But sometimes it doesn't happen due to many reasons. And if one of those reasons is due to abuse or extreme cruelty by the U.S. citizen or green card holder, then the person without status can apply for a VAWA petition. So Shima, you want to talk a little bit about what's required as part of a VAWA petition? What does the applicant need to show in order to be successful in a VAWA claim?
Well, number one, you need to show that if you're talking about a spouse, you need to show that your spouse was either LPR or USC, and you must show that it was some form that you suffered some form of abuse Remember, the abuse doesn't have to be physical. It could be emotional, psychological. And we can help you prepare what evidence is needed to prove the abuse. You also need to prove that the marriage was a real marriage or bona fide marriage. So we can also help you with what forms of evidence you need for that requirement. And it's generally important also for VAWA applicant to know the particular requirements for the type of VAWA case they're applying for. Like, for example, just as an example, if you're divorced, you may, from your LPR USC spouse, you may or may not be eligible to apply.
Yeah, that's a great answer. Yeah, I think you've covered it. Great. You want to talk a little bit about what is a bona fide marriage? What does that mean?
So a bona fide marriage means that the marriage was not entered into for immigration purposes. It means you have a real relationship, you care about one another. It was a real marriage. Also with VAWA, there's a requirement that you actually resided together, okay, during your marriage while the abuse took place, okay? So that's kind of the first step. You prove the battery or extreme cruelty. So for the marriage, the bona fide marriage part, it's the same as a regular green card application for a legal permit, to be a legal permanent resident, green card holder. We generally, obviously marriage certificate, photos, any, joint documents such as rent, the cable bill, anything you could think of that would show that it's a real marriage. Now, because these cases had, there's abuse, it's generally a little bit harder to find these documents or evidence that it was a real marriage because the marriage collapsed. If you have a regular green card petition, you're still together, you can add more documents. We have to work a little bit harder to make sure everything, we prove that the marriage is real. And then once we do that, we prove the battery or extreme abuse, psychological abuse.
Okay, yeah. Yeah, and in a lot of these cases where our clients or a potential applicant is in an abusive relationship, a lot of times they don't have the evidence, they don't have access to it. They were never privy to it in the first place. It was withheld from them. So, Greg, what do you recommend doing in situations like that where the applicant doesn't have any evidence? They don't have photos. They never took photos. They were never allowed access to financial information or bank accounts. They deleted. Yeah.
So that's very true. As with any relationship that falls apart, even if there is an abuse, people don't keep these documents. They've moved out, they've lost the photo album, they have no access to the cable bill or electricity bill. They want to put it behind them. So what we generally recommend, especially cases with no direct evidence of physical abuse, a psychological evaluation done by a psychologist that will help explain what happened, show that that they did in fact suffer. Additionally, we ask friends and family, people that were close to them during this time, to write affidavits. Just simple statements saying, I was a neighbor of so-and-so, I heard them fighting. They were so-and-so, the husband was mean to the wife or the wife was mean to the husband. I witnessed this myself. Not surprisingly, we get a lot of affidavits from landlords who witnessed this, that were able to corroborate that they came to me, they were a real couple, they moved in on this date. I overheard a lot of fighting, and then, so, you know, the applicant moved out. So anything we can get to corroborate the abuse will help us, especially psychological evaluation. It's not mandatory, but I especially recommend it.
Shima, in cases where the client has very minimal evidence, what do you recommend to your clients in those types of situations?
Well, I mean, each case is different, so you have to, there's not like a template, but basically what Greg was saying, when we don't have evidence like utility bills, you know, I would recommend you know, more perhaps photographs that you took together, text messages, definitely affidavits from family and friends that knew the couple, any any interaction with the law, for example, a police report. Definitely, then also if the abuse was emotional, psychological, we would recommend that the client go to a psychologist.
Yeah, absolutely. In cases that I've worked on where the client has very minimal evidence, which I would say is the majority of the cases, what I recommend is to use the most powerful piece of evidence, in my opinion, which is the client's testimony, which is the client's statement. That is the most powerful piece of evidence in VAWA cases. So what I recommend my clients to do is to make their statement as detailed as possible. And of course, we direct the client on how to make, you know, where to add the detail, where detail is not necessary. So that's where we step in as attorneys, and we can use our experience and help guide the client into drafting a powerful statement to support their claim. So let's go into abuse or extreme cruelty. As I think both of you mentioned, it does not always involve physical abuse. Some of you might be familiar with the power and control wheel. So what the power and control wheel signifies is that violence and abuse is usually a means to an end, and that end is power and control over the other person. So that can be in the form of physical abuse, but it can also be in the form of economic abuse. It could be in the form of intimidation. It could be in the form of emotional abuse, isolation, minimizing, using the undocumented person's immigration status, using children, and using it in cases where our clients are women, using male privilege to exert power and control over the spouse. So we can go over some examples of each of these things. So examples of economic abuse might be, I'm sorry if there's some background noise. So economic abuse could be preventing the undocumented person from getting a job. So that they don't have any independence, they don't have any financial power. Making the undocumented person ask for money from other people. Giving the undocumented person an allowance, taking money from the client, and not providing any information about the family's financial status. So those are just examples of economic abuse. Some examples of coercion and threats are, obviously, I mean, it speaks for itself, but, threatening to do something, even though there's no physical violence, threatening physical violence, threatening to commit suicide if they don't act how they want them to act, threatening to make her drop charges or blackmail if they don't do what the abuser wants them to do. Okay, so some examples of emotional abuse are putting the other person down, making them feel bad about themselves, calling them names, gaslighting, playing mind games, humiliation, and making the other person feel guilty. Some examples of isolation are controlling where the person can go or not go, who they can talk to or not talk to. In a lot of our cases, our clients are not allowed to speak to their own family. And then, they'll use jealousy to justify their actions. Okay, so examples of minimizing is accusing the undocumented person of saying, of making something a big deal, or saying that they caused it, it was their fault, denying that the abuse happened. So these are just examples. There's many examples, but at the end of the day, the point is that it's not always physical abuse. And it could be an accumulation or the cumulative effect of all of these things, or one or two or three of these things that could amount to what's required for a VAWA claim, which is extreme cruelty. Okay, so Shima, can you talk about some, of course, we're without releasing any confidential information, some cases of some examples of extreme cruelty you've seen?
Well, we've had many successful VAWA cases recently, and some examples from those cases include we've seen emotional abuse where the LPR spouse or USC spouse is threatening the applicant with deportation. That's a common threat that we. Hello?
Oh, you're good, Shima. Continue.
Oh, okay. That's a common threat that we've seen. We've seen racism towards an applicant, telling them to go back to their home country. We've seen abuse towards their religion, for example, totally degrading the applicant. And that's usually, pretty harsh on somebody's psyche. And as for other abuse cases, we've seen, we have seen some physical abuse as well. We've had applicants who have been beaten by their LPR or USC spouse. And that's very unfortunate. That's a summation of some recent successful cases.
So adding on to what Shima and Soraya were saying, what we usually see is couple gets married, and then the idea of applying for a green card comes up, and the abusive spouse does not want to lose control over this person. And they see that, oh, if they get the green card, it's over, they're gonna leave me, and they start becoming abusive, threatening them, saying things, and the relationship falls apart, and the immigrant is left with nothing. Or not interestingly, we see just as many men apply for VAWA as women in our office. You know, it is available to both sexes and sexual orientations. In these cases especially, you know, as attorneys, we become very close with the client, okay? There's a lot of upsetting as well. We take great care in communicating with the clients and having their best interests in mind. When we do this in court, I always ask for stipulations to the abuse, so it doesn't have to be discussed out in the open, because it can be very, very troubling. And you know, when you're asked to repeat, you know, your abuse so many times, it can be like reopening these wounds. And so we always take great care, and you know, in speaking with the clients, especially when they have to testify to the abuse in court. So on that note, I was thinking, Shima or
So
Sarah.
Greg, I just wanted to make a point. I'm sorry to
sure.
interrupt you, but the abuse, like in court, you're talking about VAWA while in removal proceedings, correct?
Yes.
So just wanted to let you know the I-360 has to be approved by USCIS.
Okay.
Yeah, before you the court can just adjudicate the I-485.
Okay.
Yeah.
So we'll go into.
So on that note, are there any other forms you could file in court for VAWA?
So let's take it one at a time. Let's go into procedural, the nuts and bolts later on. Let's kind of cover some of the substantive aspects of a VAWA claim, and then we'll go into procedurally, you know, what are the you know, loopholes and things you have to do to not loopholes, you know, what the things you have
Tricks
to do.
of the trade.
Huh?
Tricks of the trade.
Tricks of the trade, yeah. Okay, so I wanted to share an example of extreme cruelty, that a case that I recently won. It was a case in which the U.S. citizen partner would frequently make comments regarding the client's appearance. So and they would always comment on the food that they were eating. For example, like, isn't that too much salt? Shouldn't you be having a salad? You know, things like that. And it affected the client so to a point where she developed anorexia. So she internalized a lot of this criticism by her U.S. citizen partner, and then she developed this disorder. And the claim was that this disorder can cause death or severe injury. So that is a claim that that immigration accepted as extreme cruelty to the client. So I just wanted to share that example with everyone. Okay, so I think we've gone over substantively what's required of the claim, and like Greg mentioned, you don't have to be a woman. It's for all genders, men, women, non-binary, whatever you identify as, and any type of orientation. So It's not limited to that. And most of, I would say 50% or even more of our clients are men. So yeah, just keep that in mind. Okay, so we can go into the procedure of how to make this claim. So you can make this claim before USCIS, or you can make the claim in court, like Greg was explaining a little while ago. So Shima, you want to talk a little bit about how to make the claim before USCIS?
Yeah, so basically, if you're not in removal proceedings and you meet the requirements, you can file the claim before USCIS. However, if you're in removal proceedings, you can file the I-360, but it has to be adjudicated by USCIS.
Okay, and when you do file the petition with USCIS, are there any accompanying applications or petitions that you can apply?
Yes. So if it depends, if the client has a current priority date, you can also, for example, if the spouse was a USC, you can apply for the travel document, you can apply for the work permit, and that's also two forms of application.
Can you apply for the green card with the petition?
Yes, and of course, yes, and also the green card, yes, of course, yes.
Okay, yeah, and do you find that to be beneficial for your clients?
Yes, I do, because most clients need a work permit. We all have to work to make a living, and that's pretty important to them. So definitely, that's actually the number one thing that I get asked, like, oh, can I get my work permit too through this application?
Yeah, that's very important. I mean, like you said, like everyone needs to work, so that and having the work permit, of course, is required by US law in order to work, and it certainly helps to find an employer when you have a authorization to work in the United States. Greg, you want to talk a little bit about how to make a VAWA claim when you have a case in immigration court?
Absolutely. So there's a couple ways we go about this. One is if you're in removal proceedings, you can file the I-360 with USCIS, as Shima discussed, and wait for that to be adjudicated, and then apply for your green card in court. But USCIS will only accept an I-360 application if you were divorced within 2 years after the divorce. Correct? And but what we see a lot is people get married, then they end up in removal proceedings, and should they apply in court or through USCIS? So we have many options. We discussed on the other episode, belts and suspenders. So if the marriage was 2 years and ended 2 years prior, you could file a VAWA case through VAWA cancellation of removal, and it's done on Form 42B with the courts, and the court will adjudicate the whole VAWA case for you in court. We could, if the marriage ended within 2 years, then we can file the I-360 with USCIS and keep the case in court. Now, this is quite beneficial to our clients, because should something happen to the USCIS case, they can then reopen it in court or recalendar in court and adjudicate it that way. So VAWA cancellation in court has no deadline. If you were divorced 10 years ago, you can still pursue the VAWA in court while you're in removal proceedings. With USCIS, there is the 2 years after marriage that you have to file the I-360.
Yeah, within 2 years of death, or so that is the deadline to file before USCIS. So Greg, if a person applies for VAWA before the immigration court, as you said, it's called VAWA cancellation. if they apply for VAWA cancellation, are they eligible for a work permit?
Yes, so it's 40, it's the same form that's used for 10-year cancellation of removal, and they can apply for a work permit.
Okay. And we were talking earlier about interviews, about the claims. So Shima, when the case is before USCIS, is the applicant required to come in for an interview to discuss the abuse?
So, previously that was fairly common. Nowadays, I haven't seen much interview requests, to be honest. I just see I-360 approval, like prima facie before, and then I see for my cases, I just see a green card. I haven't been lately or seen many requests for an interview, but I have gone to them in the past. So yes, so when you go to the I-360 interview, the officer will discuss the abuse and all the evidence that you submitted with your application.
Yeah, and I agree with you. I have not seen any interviews on the I-360. If anything, sometimes they call the applicant in for an interview on the I-485. Once the I-360 is approved. And in that interview, they don't ask about the abuse at all, because first of all, it's traumatic. I don't think the applicant definitely doesn't want to go through that. And I don't think the officer wants to go through that either, or make the applicant go through that. So I haven't seen any interviews where the officer asks about the abuse. And Greg, how is it, you were mentioning sometimes you stipulate to the facts in immigration court. What do you mean by that?
So sometimes, the abuse is quite traumatic. Nobody wants to hear this, like violence, sexual abuse, people being degraded and demoralized. So what I will do is one of two things. I'll ask the prosecutor, the Department of Homeland Security. I will say, can we just stipulate to this that there was extreme cruelty? We don't want to go through this and cross-examine someone, a victim, on what happened to them. Okay, it's nobody wants to do that. Okay, especially if there are police reports, hospital records of physical abuse. That makes things a lot easier, where we don't have to ask them to, explain this all over again. And sometimes we're able to get a stipulation to the whole case together. That's always great. But if we can't get a full stipulation to the relief, then I will ask the court or DHS to have the respondent, our client, swear to the testimony written in the affidavit or their statement, and leave it at that. And if it is so traumatic, and commonly, because of the subject matter, we're able to do this quite frequently.
Yeah, we definitely want to avoid any further trauma to the client as much as possible. Okay, so one thing I do want to mention is sometimes clients are afraid to file a VAWA application because they're afraid that their U.S. citizen or green card holder spouse will find out that they filed this application. Can you speak a little bit on that, Shima?
To make it clear, it's VAWA is confidential. You don't have to worry about your abusive spouse ever finding out that you filed the application. You're not even required to put your mailing address if you don't want to. That's how safe it is to apply for VAWA. Yes.
Yes, in fact, it's written into the statute that the government cannot and will be penalized if they release any information about your claim to anyone other than you or your attorney. So your partner will not know that you filed this application. Okay, so we have some questions. So let's go through the questions from our audience here. Okay, let's see. What if I am no longer living with my spouse? Can I file for VAWA? Greg, you want to take this one?
Yes, so you don't have, I mean, we hope you're no longer living with your spouse if you're suffered abuse. And the government doesn't want you to have to live with your spouse to apply for this. So, you know, as we said, with USCIS, it's 2 years after a divorce. With court, there's no deadline. And so simply, you don't have to continue living with your spouse.
And the flip side of that is also true. If you are still living with your spouse, you can still apply for VAWA. There's no requirement that you have to be broken up or not living with your US citizen or green card holder spouse. You can, you know, maybe you broke up with them and then during the course of your case, you want to return to live with your, relationships are complicated. So maybe you want to go back to live with your spouse. You can still continue your case. Your partner does not have to know. And you don't need to rely on an abusive partner to legalize your status in the United States.
Yes, very commonly we get people come in, they have an approved petition, but then the marriage collapsed afterwards. So then we'll once again file the I-360, even though they do have an approved petition.
Right. Yeah. And sometimes they're in the middle of the case, right? Sometimes they go to their first interview and, maybe the abusive partner will try to sabotage the client and purposely answer questions incorrectly. And then they get called in for a second interview, which in New York, it's called a Stokes interview, where they separate the spouses. And sometimes they come in, our clients come into us at that point, and we can take it from there. Before the Stokes interview, we can have your case converted from a regular, straightforward marriage case to a self-petition. So, so let's move on to the next question. Okay, some of these questions we've already answered, so I'm not going to go over them. So there's a question, what if I entered illegally? Does that have an impact on the claim? Shima?
No, it does not. That's one exception to, the adjustment of I-485, adjustment of status requirements, that you can enter illegally and still be eligible to receive a green card through VAWA.
Right. That's absolutely right. What if the person has been deported? They were being abused by their partner and then they were deported for whatever reason. Can they apply for VAWA?
Well,
yeah, go ahead.
No, sorry, Greg, you go ahead. Sorry.
Go ahead. Yes, you can. We have a couple cases like this. Now, it is, difficult. It's very stressful on the families, but you can still have a VAWA, I-360 filed, and then get your green card through adjustment of status. You'd have to, through consular processing, which is done at the embassy in your home country. So it's a little bit different, but you can do it.
Right. And a lot of times they're related. Sometimes, the abusive partner purposely tries to get the person deported. It's just a continuation of the abuse by the US citizen. Okay, I've never filed a police report. No one knows anything about the abuse I suffered. How do I prove that I suffered abuse? Greg?
So as we said earlier, I think psychological evaluation. We use these in asylum cases, in a wide variety of cases. And what this does is help your credibility. You have a licensed professional sitting down with you and listening to your story and writing a detailed report as to what they heard enhances your credibility. You know, and we see cases approved with, we have some good doctors and psychologists. They will write great reports and explain to the CIS that this person is truthful and the effect that this abusive relation had on them. You know, it goes a long way. You technically, to only file VAWA, you just need an affidavit and your passport, I believe, right? But you don't need.
In theory, yeah.
Yeah, technically, you know, obviously we're going to ask for more, but you can file it, you know, with just a statement, but you have to be credible. And that's where the psychological evaluation comes in.
Right, yeah, and my, you know, I'm always a proponent of a detailed statement, so, you know, sometimes our client can't afford a psychologist or, they don't have a mental health provider. So in those cases, you know, we come up with a detailed statement to prove their claim, to prove not only the bona fides of the marriage, meaning, you know, that it was a genuine marriage, but also, so that is a service that we offer. So let's get into parent-child cases. Shima, you want to talk a little bit about those types of cases?
So honestly, we don't see too many of those cases. I personally haven't handled one in a while. So basically, it of course it happens, parent-child. For example, you know, your parent is a USC and they're elderly, and you know, I mean, I haven't seen many of them. Maybe Greg has, so maybe he can elaborate. Yeah.
So we do have a couple currently. It's particularly sad, I feel. If you're without status and your child over the age of 21 is a US citizen, you can, and they are abusing you, you can file VAWA. One of the cases we, you know, have is this elderly man came here on a tourist visa and has no family in his home country. He was relying completely on his children, and his son and daughter began forcing him to work and taking all of his money. They told him, give us all your money and then we'll petition for you. And incredibly mean to him. I mean, really, his wife passed away, the mother of the children, very nice man. And now he's left in the United States with no status. And his only connections are his two children, who are incredibly cruel to him. And in this case, we have, you know, emails, text messages, the psychological evaluation, and we're, you know, filing. We, you know, like as Shima said, it's not very common, but we do see them. You know, ordinarily, if you're a U.S. citizen and you petition for your parents, there's no wait. You can get a green card, and in this, you know, so it should apply to you know, VAWA cases as well.
Yeah, and there's also a category for children under 21 of US card holders. And those are, also very sad cases. So this would be a case where the client has a US citizen or green card holder parent, but the parent is refusing to petition for their child under 21. So those are also very extremely rare, because normally parents want to help their kids, but every now and then we see these types of cases. So that's another category. So I think we've covered a lot about VAWA. Of course, there's a lot more. All of this information is intended to be general information. It is not intended to give any specific advice to anyone. Everyone's case is different. Everyone's immigration history is different. So some of these things that we talk about might not apply to you. And what we suggest is that you speak to an experienced attorney to determine if this is the right kind of claim for you. We're here to talk to you if that's what you would like to pursue. We would love to talk about your claim to see if you have one. And we have 3 offices. We have our main office in Jackson Heights, and you want to share that address, Shima?
Yes, our address is 7409 37th Avenue. We're located in Suite 205, and that's right, like 1 block from the big train hub.
Okay, and if a viewer wanted to see you, how could they go about doing that?
So you can call the office at 718-263-5999 and make an appointment with me.
Wonderful. Okay. And Greg, you want to talk a little bit about our Ozone Park office? Where is it? How can a viewer get in touch with you?
Sure. So we're located at 10405 Liberty Avenue, in Ozone Park. Right, you could probably hear it, is the A train. So just we accept walk-ins. If I'm not busy, as long as I'm not in court, I'll be happy to speak to you. But we do recommend calling ahead, just giving us a heads up, and we'll set an appointment. Consultations are free. And
Is the Ozone Park office open on Saturdays?
it is open on
Oh,
Saturday.
wow, amazing.
Okay, from 10, yes, amazing. From 10 to 4.
Okay, and Shima, how about the Jackson Heights office? Are you guys open on Saturday?
Yeah, we're actually open on Saturday and Sunday.
Wow.
So I don't work on the weekends, but we are open.
Okay, and so yeah, the best, and then of course we have an office in Jamaica. 29 Jamaica Avenue, Jamaica, New York, 11432. We're right on Jamaica Avenue and 173rd Street. You can take the F train to 173rd Street. I believe it's 173rd or 179th Street.
It's 179th, yeah.
179th Street. And then walk on over to our office. The Jamaica office is open Monday through Saturday, and you can make an appointment with me or with attorney Shima, with attorney Greg. We have one of us, and we would love to discuss your claim with you. Please join us next week for Green Card with Gehi. Our show will be on citizenship. So we'd love to talk about the nuances of applying for US citizenship, what's required, residency requirements, the civics test, any exemptions or exceptions to those tests. So please join us next week, same time, same place. So it'll be at Friday at 1 p.m. and we'll see you then. Thank you, Shima. Thank you, Greg, for joining us. Thank you to the team for putting this webinar together, and we hope to see you next week.
Great. Thank you.
Thank you.